Good morning to everyone at today's public hearing of the Vetting Commission, established under Law Number 65 on the external evaluation of judges and candidates for judges of the Supreme Court of Justice. I'm Scott Bales, the chair of the commission, and I declare this session open. Hearing is being conducted under the Commission's Rules of Organization and Functioning as part of the evaluation process. The subject of today's hearing is Petru Pษ์UN, a candidate for a position on the Supreme Council of Magistracy Board for the selection and evaluation of judges. The evaluation in relation to Judge Pษ์UN was carried out pursuant to Law Number 26 on measures related to the selection of candidates for the position of members in the self-administration bodies of judges and prosecutors. Judge Pษ์UN is a judge at the Court of First Instance in Chișinău Court office. Judge Pษ์UN, welcome. And I apologize if I struggle at the pronunciation of your name. I'm joined by 5 other commission members. To my left, our Vice Chair, Andre Bevel, commission members Lavle Perling and Yuri Gatskin. To my right, our commission members Juliana Civanini and Lillian Anshu. The commission is also assisted by members of its secretariat, and you may notice in the room also members of the media and the public. Also present today is a photographer who will take pictures just briefly at the start of the hearing. The hearing will be conducted with interpretation between Romanian and English. To allow for accurate interpretation, I ask everyone to speak clearly and slowly. Only one person should speak at a time. The proceedings are being recorded. The recordings of the Commission's public hearings generally will be available online at the Commission's website, www.vettingmd.eu, within 3 days after the hearing. During the hearing, one or more members of the Commission will ask you questions. Please answer truthfully and completely. Your answers are important to the Commission in verifying your financial and ethical integrity. At the end of the hearing, you will be given an opportunity to make a brief statement. In posing questions, we will take into account your privacy and that of your family members and other close persons, and we will try to leave out unnecessary information such as ID numbers, bank account numbers, specific real estate addresses. For the protection of privacy, we ask you to do the same. I will start by briefly reviewing the evaluation process for Judge Pษ์UN. The commission initiated its evaluation on the 6th of December 2023 by notifying the judge by email and asking him to complete and return an ethics questionnaire and the financial declarations required by Law Number 26. Judge Pษ์UN returned the completed declarations and questionnaire on the 12th of December 2023. As part of evaluating a subject's ethical and financial integrity, the Commission also obtains information from many other sources, such as the National Integrity Authority, the State Fiscal Service, the General Inspectorate of the Border Police, other public institutions, financial institutions, and open sources. The Commission assesses the information it obtains for its relevance and reliability. On the 26th of January, 2024, the Commission asked Judge Pษ์UN to provide additional information by February 1st to clarify certain matters. He provided answers and documents on February 6th and then some additional materials on February 9th. On February 8th of 2024, the Commission asked Judge Pษ์UN to provide additional information by February 11th. He did so by that deadline. And then on March 2024, we notified Judge Pษ์UN that the Commission had identified some areas of doubt about his compliance with the ethical and financial criteria. We invited him to attend today's hearing. Judge Pษ์UN, do you wish to make any corrections or additions to the information that you've previously provided to the Commission up to this point? No? No. Are the answers to the ethics questionnaire that you returned on the 12th of December 2023 still accurate as of today? Is it?
Yes.
Thank you. Commission members will now ask some additional questions. We'll try to keep our questions short and to the point, and we ask that your answers be short and to the point as well. Commission member Lillian Anshu will begin the questions.
Bună dimineața, domnule
Good morning, Mr. PânUN. In order to clarify on certain aspects that were at the core of your evaluation, the Commission will provide you, will ask you additional questions, and one of them is related to the fact that being subject of declaration, you, during 2016-2021, have omitted to mention the rights of living in an apartment located in Chișinău, and according to the data of the Commission, you have lived in that apartment, have been living in that apartment starting even earlier, starting from 2011-2012. At the same time, your wife, being also subject of declaration, also omitted to indicate in the declaration the right of living or habiting in that apartment. And I here mean the declaration related to the period when she came back from the maternity leave, when she submitted it on in 2019 in July, and declarations for the 2020. Please let us know about the reason for not declaring the right of habitation or living in that area, in that premises. Look, we have Law 133 of 2016, paragraph 4, article 4, and I relay. And I'm basing on that when we speak about this right of habitation, and this should be declared only if it's related to a legal document. So I have not declared this because according to the Article 4 in that law, I concluded that it should be declared only when we have a contract, a legal contract that was concluded in this regard. But taking into account that I did not have such a document, I considered that it should not be declared. Till 2019. In 2021, it was declared with the National Integrity Agency Authority. But at the same time, the regulation or the instruction of NIA speaks about the fact that the right of living, of habitation, either it is included or not, or enshrined in a legal written document, it has to be declared because the instruction approved by the president of the NIA is waiving from Law 133, and this principle has been said to be a legal one by the Constitutional Court when an administrative authority is developing some regulations, and we could not have objection in this regard. It seems that you have ignored the obligations from NIA regulation or instruction. I did not ignore it because I took into account the Article 4 from Law 133, which said that this should be declared only if we have written legal documents. But since 2019, yes, indeed, till 2020, I omitted to declare with NIA the right of habitation in this location. But it was not in bad faith, with bad intention, because I declared it with other two state control institutions, with the State Fiscal Service. I have registered this right, and also I registered this with the right with the Service of Security. So I believe that there is no logic for me to intend to hide this from NIA as long as I have declared this with two other control institutions. And this indeed has been an omission, something that a mistake of mine.
Okay, do any of the other Commission members have any follow-up questions? Yes, Ms. Pษ์UN.
Thank you. I have a question. Did you ask for advice anywhere if you became subject of declaration? and for example, 2016, when you became subject of a declaration, how to declare? Just did you ask advice?
Yes, in that period, in our court in Chișinău, we had people coming from NIA who were conducting different trainings in that field, and I asked them about this, and they said that there is no uniform practice. Therefore, the letter told me that this is to be declared only if there is a written contract.
Thank you.
Any other questions by commission members? Judge Pษ์UN, do you have anything else you'd like to say by way of a concluding statement?
As a conclusion, yes, dear members of the Commission, I would like to conclude by saying that I like you to take into account the arguments, the justification I brought today in session, also the justification that I presented in written at the rounds of questions, and which make it clear that I had no intention to hide something from NIA or other control authority, and I admit that I omitted to declare this aspect with NIA, but I declared it with the other two institutions, with the State's Fiscal Service and the Service of Information or Intelligence and Security, when it was related to the state aspect. So I did this immediately. As soon as I found that I omitted to declare with NIA this right, I corrected this thing. Therefore, starting with 2021, 2022, 2023, this right of habitation was declared also with NIA. And moreover, I want the Commission to take into account that the right of habitation refers to a real estate, which is a room in a dormitory, 18 square meters almost, which was acquired as a right of ownership by the owner in 1998 with the title free of charge. So I had no relation with this owner of this real estate. Thank you. This would be all.
And am I correct to recall that the owner is your wife's aunt?
Yes, the owner of that real estate is the aunt of my wife since 1998, and she obtained it free of charge after the privatization process started. And the economic or market value of the real estate is smaller than my annual salary as a judge.
Thank you. We've come to the end of today's hearing. Judge Pษ์UN, thank you again for your submissions and answers to the Commission's questions. After the hearing, the Commission will approve an evaluation decision stating its conclusion whether the candidate meets the criteria for ethical and financial integrity under Law Number 26. The Commission will strive to complete its evaluation decision and announce its conclusion as soon as possible. It generally seeks to do so within a month after a candidate's public hearing. This hearing is now closed. Thank you and good day to everyone.
Thank you.